particularly talk about what is the contractor trap and how might you avoid it. Next slide. So a little bit of background on myself. As I mentioned, I'm the Senior Director of Sales for Globalization Partners. We are a global PEO. We're based in Boston, and I'm based in California. And what we do is we help companies expand in countries where they don't yet have an entity. And we do that by putting their employees on our payroll and assigning them back to the client. And we do that in over 150 countries. Prior to that, I worked for High Street Partners, which is now known as Radius, where I worked on the other side, where I was involved in advising on entity setup and all of the services that go with that, accounting, payroll, tax, and compliance. And before I moved to the US, I was a headhunter for 10 years in London in the UK, where US companies with their pan-European recruitment strategies. So I'm very familiar with the cross-cultural differences that US companies encounter when they do business overseas. Next slide.
Great, thank you, Jane. Hi, I'm Steve Wilson. I'm a partner with Osborne Clarke. Osborne Clarke's international law firm. We're headquartered out of London in the UK, but we have 22 offices around the world. We're a full-service firm, and I've been located in the US since 2007. To start with, I was over in Silicon Valley, and last year I moved to New York. And in the US, we have representative offices working with US clients as they go overseas. So really, it's from the very first step into an overseas market right through to expansion, acquisition, and dealing with the highs and lows of operating in an overseas market. I'm an English qualified lawyer and have quite a wide experience in dealing with all sizes and types of businesses across a range of issues in a range of countries. So hopefully you can add the legal aspects of the issues that we're discussing today. Next slide, please. Great, so we thought we'd start off by looking at some of the considerations that most businesses look at as part of the first stage of their deliberations when they're planning to go overseas. Now, this could be going overseas for the very first time or going overseas for the 100th time and looking at a new market. And generally, we've summarized here sort of 4 areas that need to be considered that help drive the decision as to where to go, when to go, and how to go. And what we're focusing on today is more about how to go, how to represent your business overseas, whether that's through a contractor, whether you engage and put a full subsidiary on the ground and engage employees, or whether you use a PEO and go take a lighter touch as a start. What we'll do is we'll run through each of these, and then we'll give you a little bit more detail on a number of the issues, and then we'll revisit this slide at the end so that we can kind of summarize where we've got to, and hopefully it will put some of these a little bit more in context for you to take away, hopefully as a useful sort of reference point. So if I look at the 4 issues, the first is really the objective. So why are you going overseas? Many businesses often think of it looking at an overseas market to extend their sales, and so sometimes it can be one person, sometimes it can be 100 people, but they already have operations within the US, and the idea is that they're looking to add to the revenue, add to the bottom line, add to profit by going beyond the US market and start talking to overseas customers. Sometimes customers have actually proactively come to them, and so actually they've been drawn into an overseas market, sometimes intentionally and sometimes unintentionally, but either way, the decision is taken to go overseas. Other issues are sometimes more operational or sometimes based on research and development. So if there's a particular skill in a particular country, you meet somebody at a global conference or somewhere else that, or by reputation, and you decide you want to have them part of the team, but they happen to be located in another part of the world, that's another reason for looking at some of the issues we're going to discuss today. Service delivery, often where you are either delivering goods or you're implementing software, that there might actually be a service delivery with it on the ground, or it might be more of a customer delivery or customer services process where you need people within time zone that the local regulations that they need to deal with. And finally for our list, at least for the time being, mergers and acquisitions. Very often a business will launch in an overseas market by actually acquiring a business. It's a much faster approach, and we'll talk a little bit about the pros and cons of that. So if we move on to once you've decided what the reason is, and it may be more than one, then the next question is going to be, so how big do we need this operation? Many people make the assumption that going small therefore means that they can be a little bit more nimble to start with, and particularly if they're assessing the market and they don't have a lot of customer traction at that stage. Some people just want to go in and blitz the market and really see how best they can achieve their strategy for the other countries. So that's a consideration that needs to be taken into account, and that's probably the biggest driver for what we'll be talking about today, because that will very much influence what shape your HR and your engagement strategy should be. The next point is how urgent is the acquisition of talent. If you decide that you want to go overseas and you found the absolute right candidate, then you have to grab that person quickly before they go elsewhere. That's great, but sometimes, depending on the jurisdiction that you're looking at, it can be a bit of a slow process. If you're looking to register or set up a subsidiary or a different legal entity overseas, or set up your own branch office, that can all take time. It often includes obligations to set up bank accounts, and if anyone's tried to set up an overseas bank account, they'll definitely know that that can be quite a challenge and take quite a lot of time. So it's not, sometimes setting up a formal overseas entity is not a quick process. Employment contracts, if you're going more formal, you might get into a process where an overseas employee wants to negotiate back and forward an employment contract. You probably, if it's your first step overseas, won't be aware of the formality in some jurisdictions of having an employment contract, so you'll need to take advice to get that prepared, and it will be very different to an offer letter that's often used in the US. And if it's a country that's not, English is not the first language, often you'll need to have that translated as well. So a number of different hurdles, I suppose, slow you down. And then, of course, benefits. Everybody in the world expects some sort of benefits. They vary from country to country, but actually accessing those benefits and getting them in place can take some time, particularly if you have a new operation there, you don't have any credit history, you don't know who to go to, and your US service provider is unable to help. So just bear in mind, if you want to move quickly, that you just need to take that into consideration, put that into the timeline, which will help you decide on which route to take. Finally, there's the risk mitigation. This can vary again depending on what your people are going to be doing on the ground. So sales versus kind of back room. Permanent establishment is something that those who have gone overseas before will be familiar with, often referred to as PE. It's really a tax test, and it really is the does your operation become permanent in that country? And it's usually at that point you often receive a welcome letter from the local tax authority, who are basically looking to pick up with you. Sorry, I just noticed that dropped a little bit. So let me just go back on that. Permanent establishment is when you have a greater presence within a country, within a jurisdiction, And that's a very grey area. So the tax tests vary from country to country, but it's one of those areas that you won't know until you know you have a permanent establishment. If you're selling into a jurisdiction, you'll want to go in all singing, all dancing, make sure that you have a presence there. You'll have employees handing out business cards with your name on it. You'll likely have an office. At that point, you pretty much know that you have a solid office, you have a permanent establishment. Therefore, you need to think about registrations, filings, tax payments, that sort of thing. Once you have a permanent team there, they will all be protected by local laws. So your home country law, your law of the headquarters will not fly overseas, irrespective of what you give them in terms of engagement or employment contract. The local laws of the country in which they are based and they're working will protect them, and that can be a very, very different as you go from country to country. And finally, if you're sending either your own people into the overseas country, or if you're moving people from country to country around the world, bear in mind that immigration will be a barrier to the free movement of those employees. And so there's a process there that will need to be adhered to, just in terms of getting the visa for the individuals or getting a license for the business, but that will have a slowing down process. So again, you just need to think about sort of how you want to manage risk in the country, whether it's a light touch or whether you're going in a little bit stronger. Right, next slide, please.
So, what is the independent contractor trap as we're defining it? When I speak to companies entering a new market, so often they say to me, well, my objective is just to test the market. I really don't want to have all of the hassle, the cost, and the delay of setting up an entity just to test the market. I don't want to go through the Know Your Customer regulations to set up the bank account. I just want a low touch. And for that reason, they'll often take the route of hiring somebody as an independent contractor. There's also a number of contractors who actually prefer that route. In some countries like the UK, individuals will far more likely set up their own limited company. So you pay a limited company and pay them as a contractor that way. But while it's something that can certainly work well at first, you can get up and running quickly, you can find talent quickly, it can store up a number of problems for you. And I would say the first one is, are you actually getting the best possible hires in that country as contractors? And if not, then are you limiting your business performance in that country because you don't necessarily have the best people? Hiring as contractors comes up time and again when I'm speaking to global talent leaders, that it can limit the talent pool. And that reason is that employees can get much better benefits overseas, statutory benefits. I mean, for instance, in Australia, the employer contributes 9.5% towards the employee's state pension plan. In Brazil and many other countries, the individuals will receive a mandatory 1 month of pay as an extra bonus. You may well have heard about the 13-month bonus, and that's what it is. Mexico has that too. Many countries have got very strong socialized medicine. France, Japan, Germany. So socialized medicine is very strong. They also, as an employee, receive better labor law protection. At-will employment is a uniquely US concept. There is some form of notice, whether it's from a few days to a few months in other countries, and there'll be legislation around the circumstances in which an individual can be terminated. So an individual, particularly if they've not worked as a contractor before, and they're not used to handling the tax situation, they're not going to want to work as a contractor. They're only going to want to work as an employee, and that can cut a level of talent out. Another issue is something that's familiar to us all in the US, similar to the 1099 scenarios in the US. Is an individual truly a contractor, or are they really an employee in disguise? And if an individual is misclassified into some significant assessments against the company in terms of back taxes, penalties, and so on. And I will show you a little bit more about that on the next slide. And I think the third situation is the exit strategy. If you choose at some point to part company with your contractor, the contractor can use their understanding of misclassification to threaten to whistleblow to the authorities in order to get a significant payout. I had a client go through the pain of this with a contractor they were looking to part companies with in Argentina before they came to us. And particularly in Latin America, individuals have got very easy access to labor courts. So it is particularly a red flag area. But if you're looking at it also, you've grown in a country, you've got one, you've got two, you've got maybe three contractors, you've got good business going, it's time to set up an entity, you want to hire more people. At that point, it can be very challenging to convert your contractors to employees. In just about every situation, I've seen them negotiate for more money. They will say that the amount that they receive in their pockets once employee withholding tax is taken is less than they would have got as a self-employed person. And you don't know if they've even been paying their taxes, and nor should you. That's not your responsibility. But they will come back and negotiate hard. So I've seen contractors grandfathered into a newly established entity with a higher package. And that can also cause benchmark that you want to bring in as straightforward employees. So while certainly hiring as a contractor can be an easy fix and an easy start, it sidesteps the need for the entity to begin with. It can store up certain problems later on. Next slide. So, as I said, we're all familiar with 1099 scenarios in the US, and there's some very straightforward indications about whether an individual really is a contractor or if they're really an employee in disguise. Do they have a portfolio of clients, or are they working just for you? Do they have a manager within the client company, or do they fully control their own actions? How are they paid? Are you paying them a fee for service, or do they receive some form of benefits which would categorize them as an employee? Do they get vacation? I have several conversations a month with companies about contractors, and I would pretty much say that in every case, deep down, they know that these individuals really walk and talk like an employee. There are very few instances where they would pass the sniff test in terms of being a contractor. Next slide, please. And I also get asked, well, I mean, how high could those costs run? You know, can it really get that high? So I did a bit of a back of an envelope calculation about what might happen. So let's say you're paying an independent contractor a fee of $100,000 a year. And you're in a country that might have employee withholding tax of 35%. If you are assessed as having a misclassification issue, the authorities are going to take the amount you've paid to the individual as a net amount, because it is the employer's responsibility to withhold taxes. So the first thing that will happen with that amount would be grossed up with withholding tax. So that would take that, in this instance, to $153,000. And then on top of that, there would be the employer payroll taxes. I picked 46%, that's the rate currently in France. It might be a lot lower. It might be somewhere closer to, say, 17% in Singapore or Australia. But it might be a lot higher. It might be something like 65% in Argentina. So anyway, I picked in this example 46%, so that would add an extra $70,000 on. And assessments can go back several years in a number of countries. So let's say this individual has been with you 3 years. Then 3 years worth of withholding and payroll taxes would come to $370,000. Now, if you have a savvy contractor, especially one who likes being a contractor, they'll know the way around misclassification. You can also see why the authorities can give certainly a lot of leverage to get a payout to exit the company should you wish to part company. Now, I'm not saying that all of this will happen to you. I don't want this to be a catalogue of woes of a walking disaster about contractors. But contractors are, as with other aspects of business, it's an assessable risk. And what I would flag up is that a business needs to assess the risk on a case-by-case basis, country-by-country basis, and keep that under regular review. How many contractors are there and where are there, and what is the potential exit strategy for that? Next slide, please.
Great. So, as Jane just explained, in terms of classification, there are certain characteristics of a contractor and of an employee, and I expect most of you are very familiar. 1099 versus W-2 is quite a well-known kind of differentiation. I would say, and now we're obviously trying to cover the rest of the world, which is a very large place. So clearly the nuances of this will vary from country to country, and the overriding advice from this webinar is to take close advice before you do anything, because not only do countries vary in terms of their rules and regulations, but also they change on a very regular basis, very often influenced by case law and by disputes around what happens if you get a classification wrong. So if you work on the assumption that it is pretty similar in terms of classification between the two, then your next kind of natural assumption would be, well, okay, we take that risk in the US. We've got 5 contractors, 50 contractors, whatever you have, and so we understand what the risks are and we're willing to take that. I think that this is where there's a material difference in assessing your risk within the United States and within assessing your risk elsewhere. And that comes down to something we've already picked up on a little bit so far, which is there are very, very different employment laws around the world. Because employment at will doesn't exist, that also obviously means that every employee has certain minimal rights that they're entitled to. And there are plenty of horror stories out there of US companies that have blundered into an overseas country and worked with an employee or a contractor who has taken them for a ride, because they know often that some of these rules won't be known about, and therefore they actually are proactively out there to con you. So please do try and avoid those people. Obviously very difficult to identify them, but by taking a few kind of simple steps around considering what structure to take and then when to go down what route, you can obviously alleviate that risk considerably. So some of the examples I just wanted to raise on this slide. So what are the consequences for misclassification? Some of the consequences are financial. You mentioned a moment ago that the idea of notice periods. So that ranges from maybe a week's notice where you actually have to pay the employee out a week's salary or wage, but it can actually go up to 6 months, 12 months. If you're appointing a country head or a regional head, then the expectation that they would have a 12-month notice period is not unheard of. Again, I would counsel you to just check with what is market standard at that time within your industry before you agree with your future employee, because they obviously will be presenting it in a particularly positive way. But the point is that if you've taken on a contractor, then it turns out they're an employee, you don't know what terms they're going to be protected by. So this includes things like a notice period. This includes unpaid time off. So that's both vacation time, but also many countries in the world provide a certain allocation of sick leave. It will be obviously the fact that you have not deducted payroll taxes and social security payments at source, which was shown on Jane's last slide. But there are also other regulations around minimum wage. Contractors are not subject to minimum wage, whereas employees are. So particularly if you have a large amount of relatively low paid contractors, then you start getting into issues about have you actually been paying them enough, and do you need to effectively pay damages to them to pay the difference. And of course, if you've had these people for 3 years and you've got 100 of them, then that starts multiplying out quite quickly. Additional, in places like Europe, we have working time regulations, and that requires every employee to keep a note of the time that they spend at work, and they're not entitled to spend more time. Certain countries enforce that in different ways. Certain levels of employees are subject to it, whereas others are not. So again, it's a bit of a minefield that can become very expensive if you get it wrong. I thought it'd be useful just to mention a couple of situations where this has been a problem for a US company. I think I won't use the name, but many people are familiar with certain car sharing or services that have been rolled out around the world, and the drivers that have been working for the business have been reclassified, certainly within Europe, as workers, which is a type of employee that have got certain rights, not full rights, but it still includes things like paid time off and the working time points I mentioned, and a minimum wage. So clearly, if you think about the number of drivers in any one city and multiply that out by the number of countries in which they're operating, you're getting to quite a hefty bill, and obviously you'll be aware of similar misclassification issues that have been brought up in the US, and so that becomes extremely expensive. There was another case where valets were considered to be employees. Again, in most cases, you would expect them just to be ad hoc sort of consultants or contractors. And in this particular case, they had a certain degree of permanency about them. So one of the characteristics Jane mentioned a moment ago was that they don't have any other employment or paid activities. And so if you're their only source of income, that starts to point towards the fact that they're an employee rather than a contractor. And even things, if you're in the service industry and they wear your uniform, then that's another flag that they could well be an employee. So unfortunately, in all of this, as it is in the States, there's no clear, definitive definition that where you could just go down a checklist and say yes, they're an employee or yes, they're a contractor. Clearly, there are areas and characteristics that start to influence one over the other. So just worth thinking about that. And to the final bullet point there, I say again, it does vary country to country. Some countries have less regulation and I suppose are less likely to result in misclassification or actually in employees taking action. It depends how active trade unions are and whether class or equivalent of class claims are brought. So again, just bear that in mind when you go into a new market that you haven't got much experience in. We can move to the next slide, please. So this is a huge area, and we could do a webinar just on this topic, and I've got 4 bullet points to explain. So this is something specific to Europe and is pretty quirky, actually. Many people, including businesses within Europe, will be unaware of some of what I'm about to say. So back in 1994, the EU introduced what's called the Commercial Agents Directive. So the purpose of this law was all countries within the EU, which is currently 28 countries, including the UK, at least for the time being, had this law applied to them. What it does is it protects sales agents. So sales agents are defined as self-employed intermediaries who have continuing authority to negotiate, and sometimes it's also to negotiate and conclude the sale and purchase of goods on behalf of and in the name of their principal. So obviously this applies in a situation where you have appointed a sales contractor that is selling goods, and I'm afraid to tell you that goods sometimes include software and sometimes doesn't. So that varies from country to country. But it is a situation where you give them authority to go out and sign sales contracts on your behalf. So you can imagine that much of the time these type of contractors are out there selling your services, selling your products on your behalf. They're negotiating with the customer. They're concluding the sales. They're sending back the orders to you to fulfill from afar. And the issue is that they would therefore be considered what's called a sales agent. So a sales agent is a contractor. I just did within the definition they're self-employed, so they are a contractor. However, unfortunately, they are a certain type of contractor that within the EU attract employment type protections. So I'm afraid to tell you that irrespective of the contract in which you engage them on, they will be protected by these laws. So even if you've engaged them on your typical US contractor contract, if you've even localized it for use overseas in Europe, that doesn't matter. The laws will protect them and they will override any of the terms of your contract. So basically what it means is that they will be entitled to a notice period, which for most contractors is pretty unusual. The notice period is 1 month if you were to terminate them within the first year, 2 months within the second year, and 3 months for the third year onwards. So that's obviously slightly surprising to start with. The bigger issue and the one that is why I'm specifically mentioning it today is that all sales agents are entitled to a termination payment. Now, obviously, with a contractor, you would imagine it to be a clean break. You terminate them, usually with immediate effect, and they would walk away and you would walk away. I think I've gone offline. Okay. I'm back. Hello. Right, I realized I went offline. I went offline there, so I paused, so don't have to repeat it. So so in terms of the termination payment, the sales agent would be entitled to one. And again, unfortunately, depending on which country it is, depends in which those termination payments are calculated. Sometimes you can clarify within the contract if you know about the commercial agents directive and you've applied that to your contract. You can actually say which of these two termination payments you prefer to use. So the first is called the indemnity payment. The indemnity payment is usually a multiple of the business that the sales agent has introduced to you, or that they've grown existing business by within the last, I think it's 3 years. Again, I think it varies from country to country. So that would be effectively a payment probably based on the commission that they've earned or a proportion of it. So usually that is the one that's preferred by the business, by you as a principal, because it is capped, and the cap varies from country to country. There's a bit of a theme here. If you don't define it as the indemnity, and the indemnity is not the one that is preferred within the local laws, then it will be a compensation payment. And unfortunately, a compensation payment is calculated on the loss of value to the agent. So obviously, if you've just terminated that agent's livelihood, then they can come up with a great number in terms of what you owe them, because they had an expectation for the next 10 years they would be earning a certain level of commission from you. So I'm flagging this because it can be an expensive exercise if you've gone in unawares and suddenly you terminate and the guy turns up to you and tells you that actually he was protected by the commercial agents directive, and he would like you to pay the termination fee. Generally, the agent needs to make the claim within 1 year, and it might sound surprising, but actually a lot of sales agents probably don't know they've got this protection. So actually having that 1 year period is quite handy. There are a number of legal cases here. There was one that went all the way up to the European Court of Justice, where it was a medical device distributor, and what had happened was the principal was based in California, gave them their typical contractor agreement under California law, obviously didn't include anything related to the commercial agents directive, and when they terminated the contract with the commercial agent, he turned around to them and said, "I'm protected by this." It went to court. It went all the way up the national courts and ended up at the highest court within Europe, the ECJ. And at that point, the court ruled that he was in fact owed an indemnity payment, and the business was required to pay him a multiple of the commissions that he'd earned over the previous 3 years. So clearly, it is something that you want to avoid if at all possible. I think that's probably all on sales agents. So next slide, please.
So if we're looking for alternatives to contractors, how might we do that? Really, the two routes are setting up an entity or using a global PEO. And both of those have a very definite place and lend themselves to different scenarios as being a good solution. So let me start by explaining what an employer of record or a global PEO is. And by the way, they are the same thing. It's just different people use different terms for the same thing. So a global PEO will hire clients' candidates through their local entity. So the client will source their candidates, and they will use then the employment infrastructure of the PEO to hire these individuals. So the PEO will provide a locally compliant employment contract. They'll run payroll. They'll provide benefits, all statutory benefits, and some PEOs can also provide additional market norm benefits. They'll provide a way to reimburse expenses to the employee, and they'll do all the local compliance, the sort of the W-2 equivalent paperwork in other countries. Some countries might require an annual medical, whatever it is on a compliance perspective. As the employer, the PEO is responsible for those items. So what the PEO does is it hires this individual and it assigns the services back to the client. So the employee will walk and talk like the client's employee, but technically the individual is employee of the PEO. Next slide. So why do companies use a PEO? Well, first of all, it broadens the talent pool. As I mentioned before, there are a number of people who will be hired, want to be hired as an employee because of benefits and local labor law coverage, but not as a contractor. It's a very fast solution. You can hire in days through a PEO because the entity is already set up. So if that unexpected hire pops up, the VP of sales walks in to see the VP of HR and says, "Oh, I've just found this amazing person in Korea. Just put them on the payroll for next month." What's the VP of HR meant to do with that? This is a solution which will fix an employment contract and get the individual hired within days. It's also very flexible. A global PEO is on a month-to-month basis typically. So if the employee leaves, whether they resign or whether they're terminated, there's no corporate structure left behind to maintain a local entity. They're free and clear in that country. And it also reduces risk. Obviously, it sidesteps the contractor risk because this individual is an employee from the get-go. And it also transfers the responsibility for compliance from the client to the global PEO. They need to be a compliant employer. And when I speak with HR directors who've got responsibility for their own entities, they tell me this is one of the things that really keeps them up at night. I mean, it's one thing to Google something that you might, I want to know about maternity leave in Sweden, but it's another thing to not, how can you Google what you don't know? So this is where the Global PEO is responsible for keeping abreast of local labour law. Next slide, please. So some typical scenarios that work for a Global PEO might be, as we were saying earlier, that first hire in a new country. You want to test a market. It's often the first salesperson in the country. Test the market with minimal investment before you want to set up an entity. See if you get traction of the business in that country. And as I say, typically this is salespeople that I've seen. And if it doesn't work, you're free and clear in that country. An outlier hire. This is somebody that I would say is an individual where there's no long-term growth in a country. So I see a lot of, for instance, quality assurance manager who oversees a third-party manufacturer in China. You don't want that person being hired by the Chinese manufacturer who they're overseeing. So having this hired by third party is a good one. Some brilliant software engineer in Lithuania. The tech team has to have this person, but you've no plans to grow a tech team in Lithuania. That's an outlier employee. Convert contractors to employees. I know we've touched on that a lot. I think one of the key triggers I see for that is a company that is approaching an IPO or a public company that needs to do some cleanup. It is a known risk about how many contractors you have, how long they've been with you. I did have one public company just approach me just before the holiday. Their issue had got as far as the audit committee, who had mandated them to fix it because they wanted to get their arms around that risk. Non-profits, they will often grow through contractors and want to, on one hand, manage their risk, on another, want to see about maybe rolling out some equitable benefits across the whole organization. So there are a number of drivers there. Acquisitions. If it's a spin-off or a carve-out where the buyer is buying, say, a division of another company but not the whole company, then the assets will move over with that acquisition, which includes the people, but it doesn't necessarily, it won't include the local entity from the seller. And we've been doing an increasing amount of work where the buyer might have like 3,000 to deal with, but they've got 30 overseas across 20 countries. And it's a disproportionate amount of work to need to take care of all those by deal close. So we will take those on and move them to our platform to help the acquisition go smoothly. And then I would also say, there are many situations where getting an entity registered because of the pace of growth of business is absolutely the right way to go. But it can easily take 6 to 9 months to set up in China, in the UAE, in Brazil, and yet you found good talent already. So a global PEO in that instance is a good stopgap to make sure that you've got continuity in the business. So areas that might make sense for an entity. So next slide, please.
So we've obviously covered quite a range of issues over the last 50 minutes, and so what we thought would be useful is just to give you some of the thoughts around when should you actually consider putting an entity in and hiring your own employees versus when is the better time to consider a PEO. And I think there are a number of occasions where it's very clear which we would certainly advise you to take. And for the entity, I think that when you're looking at growing your business fast, where you're looking at taking on a number of employees, and that's always a very gray area. What's a number of employees? I mean, I'd say more than a handful, then you're probably looking at an entity as your preferred route, partly because you're likely going to be looking at a greater infrastructure within the new market, the new overseas market that you're considering. At that point, you can also consider what your international tax strategy is. So if you're looking at generating sales overseas, then that's when you would have your tax lawyer or your tax accountant to take a look at where those sales, where the revenue is going to be recognized, where the profit's going to lie, where the preferred tax rate is, and therefore very often when you start to have a number of overseas offices and growth and customers, that's the point at which you can actually start saving money through efficiently structuring your overseas tax group. And also at some point it might be that you've outgrown the PEO model, which, as Jane just described, is great and very flexible, but at some point it might be that you just need, or you feel it's time that you take control of those individuals for the purposes of continuing your overseas objective. I think Jane mentioned it, and I think I mentioned it earlier. I mean, in terms of the setup process, you just also, it's worth taking into account what that process is. In some countries, it's very simple. You can have an overseas 100% owned subsidiary of your US entity within 24 hours. I mean, in the UK, you can do it very, very fast. However, don't assume that that's the be-all and end-all of that process, because, of course, you might have a legal entity there, but if you're then bringing on employees, you'll need to pay them, you'll need to provide them with benefits. You'll need to, if you're selling and or even buying things within the overseas entity, then you'll need to have a local bank account that has that can handle the local currency. You'll need to register for taxes, which takes time. And so there are other processes that need to be set up. So I always, when I'm talking to clients about their first overseas expansion, I always emphasize that there's an element of patience. Not everything can be done overnight. I've just obviously spoken about the best case scenario in the UK. If anyone's ever opened or sought to open an overseas entity in Brazil or in China or in India, I think you should assume that it could take up to 6 months. Sometime I've been told by some clients that it took them 2 years. And so it's clear that if you're looking to start doing business in one of those countries, you know that the timeline you have to assume is 2 years, then you really want to have a solution to actually start doing business sooner, rather than sitting around waiting for notaries or documents to be processed or whatever it takes to set up that entity. So again, getting local advice, local knowledge in terms of what you need to do and how you need to do it. And also there's been it will be worth considering what your domestic strategy is, because if you plan to exit within the next 12 months, then probably setting up an overseas entity in Brazil, where it might take longer than 12 months to get it in place, it might be better to take a more temporary approach to that and have your buyer decide on what they want to do with the process going forward. Similarly, if you're actually, Jane mentioned acquisitions and being able to pick off lots of different employees within different jurisdictions. If you're acquiring a bigger organization with a number of employees within a particular country, depending on how you structure it, you might need to set up your own entity, or you might actually be buying an overseas entity as part of that acquisition. And so you're inheriting not only all the employees, but the good news is you're inheriting the processes, the payroll will already be in place, etc. But you're also inheriting a lot of the more negative issues around the liabilities of those employees to your acquisition. So that's when you'll be looking to your M&A lawyer to ensure that they're asking the right questions within that jurisdiction. and not just the typical questions that you would ask if you were doing a US domestic acquisition. Sorry.
Okay, let's
Jen,
the next
do you
slide.
want to pick up on PEO?
Yeah, so just
sorry, there was a second half slide.
At the end.
Go back
yeah. So I said we'd revisit the final slide. The objectives about what you're wanting to do overseas, you could make a case for either of those going the entity or the PEO route. I think that the second, third, and fourth points are far more likely to direct you as to which way to go. If you're looking for a small footprint, then an entity can be a sledgehammer to crack a walnut for one person. But if you know that you're going to have a large footprint, then thinking about your entity structure right from the get-go could be a very important step. Steve, do you want to touch on the other two?
Yeah, sure, absolutely. So the speed of hire point is the one that I just made in the last slide, around building in the appropriate time frame to get the incorporation, get the registration, not only for the entity but elsewhere. Bank accounts, Jay mentioned earlier, know your client checks. I'm not sure how many of you are familiar with that, but so I thought it'd be worth touching on. In many jurisdictions, in order to set up an entity, but also definitely to set up a bank account, there'll be a lot of information that the bank will require on the ownership structure of your business. If you're privately held and it's closely held, there's only a handful of shareholders or stockholders, that should be relatively straightforward. Obviously, there'll be a cultural shift, because you'll have to provide information that is typically kept wholly confidential within the US and no filing requirements, but overseas, a number of people will ask you for who owns what in the business, and they'll need to know some of their personal information. Where you're owned, or more than 25% of your stock is owned by a venture capital firm or a private equity or any sort of institutional entity, then there might be further requirements that, surprisingly enough, require details around the fund structure of your investor. So if you can imagine that you're trying to set up a bank account in France and you're being asked these questions, and you're having to go back to your CFO to ask for what the structure is, and you're asking the CFO to ask your brand new investor to start disclosing how their own fund is set up, that can cause quite a few raised eyebrows and definitely can slow the whole process down. So I have heard of situations where the bank account can take many months to set up. And sometimes, depending on the jurisdiction, for example, in Germany and France, you need to have the share capital of the new business into a local bank account before they're able to register the company. So, that means that your entity is not up and running, and so you're not going to be locally hiring your employee. One question I am asked quite a lot: it is possible for your US entity to employ an overseas employee. However, you still need to have a local employment contract. And from a legal liability perspective, it's better not to. It's better if you're going to have an overseas entity, it's better that the local entity hires it. To pick up on the benefits point and the question that Lisa raised, what do you do about benefits in different countries? So the issue around benefits is that if you're not going the PEO route, then you would need to go and work out what the market standard is within those countries. So in some countries, you would expect, an employee would expect healthcare. In others, they wouldn't. In other countries, they would expect contributions to their retirement funds, etc. So, and then finally, risk mitigation. Permanent establishment, as I've talked about already, anything where you're in control, you're in charge, means that you're going to be subject to local laws and regulation. Jane. Okay,
thank you so much. I know we're right up against the hour, so We'll certainly follow up with people directly with any questions in the chat box. And you also have our contact details on this final page, and we will be mailing out a copy to you. So do feel free to follow up with us if there's any individual questions that you've not been able to ask by the chat box. But we'd very much like to thank everybody for attending, and we really appreciate your time. Thank you so much.